you're right. Napsters began in mid 1999. So the DMCA was just before it, but I remember, there was basically proto Napsters already starting at that time, and MP3s were flying around the internet, and that was driving it. And Napster, of course, tried and went and flamed for a while, and then burned out because of the DMCA.
Well, and I don't know that anything was flying around that back then, Anthony. I was putt-putting at 56.6K modem, right? Like it was slower traffic.
Have to wait,
slower traffic.
Wait like half an hour for the song to download, and
yes.
Yeah.
Yes.
Of course, I didn't actually do that myself, but. Pirated shows on YouTube and monopolies on the beach. This week, here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Wednesday, January 28th, 2026. And ladies and gentlemen, we have two very brave IJ attorneys here today who somehow have made it into Institute for Justice headquarters in Arlington, Virginia, where it is basically an apocalyptic scene of snow, ice, people eating cats, rats fighting with men for their very survival, and yet somehow my colleagues have made it into the studio while I sit here safe in a basement in Minnesota. A lot of people in Minnesota aren't safe right now, where it's also very cold and there's a lot of ice. But I'm fine. But my colleagues were not friends for a while, but they made it into work. And so we're all here ready to share some stories from the Federal Courts of Appeals with you. So one of them, interesting enough for a show that this week is on YouTube, will be about shows on YouTube, although be a very different kind of show, not a show that is made free for the public to educate them, but a for-profit show that I believe is in Spanish, that is being pirated. Then we will have a very different kind of opinion, and that is about a beach monopoly in South Carolina. So the first one will be from the 11th Circuit, the second from the 4th Circuit. So it's a very East Coast show today. But first I want to introduce who will be doing the beach opinion later, a first-timer on IJ, and that is Sophia Henderson. So Sophia, she is a attorney with us at IJ now, but she went to Washington and Lee School of Law. She also went to, now I'm going to get this wrong, Sophia, Sewanee, the University of the South. Okay, I'm about to be corrected, and we are very happy to have her today. She's also a philosophy major, which is a favorite of mine. But Sophia, tell us a little bit about yourself and how I mispronounced your college.
Hi, Anthony. Thank you so much for having me. You're very close. It's Sewanee.
Sewanee. So it's not like Shawnee River. It's Sewanee.
Sewanee.
Okay.
If you're really pronouncing it like a local, you'd say Swanee.
Oh, it is Swan. Okay.
Yeah.
That's easy.
You were super close. But yeah, I graduated law school in 2023. I clerked for 2 years for a federal district court judge on the United States District Court for the Eastern District of Kentucky. Had a really great experience. Kind of always knew that the type of work that IJ does is the work that I want to do. So I feel like clerking prepared me really well for that. So I'm super excited to be here.
Yeah. So you were a district court clerk for 2 years. Now, I got to say, so I was an appellate clerk at a state court for 1 year. District court clerkships terrify me because you have to do things like write orders and help with discovery disputes and that kind of like real law that frankly, yeah, it scares the bejesus out of me. But what is it like? What should someone know when they're getting into a district court clerkship?
Yeah, it's definitely, I would say there's a very large learning curve when you first start clerking on a district court, and everything just kind of comes at you all at once, and it's a little bit like sink or swim.
Uh-huh.
But I was super lucky. I had a wonderful judge, and I'm really glad that I chose to do 2 years because I think it can take you a while to get used to it. But then once you do, it's like, it was great. I absolutely loved it. And I feel like clerking on a district court is one of the best jobs you can have right out of law school because every aspect of litigation you kind of get thrown right into it. And so things that you understand maybe on an intellectual level in law school, you get to understand them like on an actual practical level in terms of the day-to-day of litigation. So it was a great
Absolutely.
experience.
I mean, of course, I've spoken to many people who have district court clerkships, and the just practical experience you have from that side of the bench then really helps you when you're thrown into actual litigation. So that's good. That's good to know, that a practical tip for some of our listeners. But we have more practical tips when it comes to pirating videos, or maybe trying not to have your videos pirated. So Dan Nepper, our CEO and CFO and general counsel here at the Institute for Justice, he's a practical guy, right? He comes up with these cases that aren't about some highfalutin constitutional matter, but like actual real stuff. And he came to me and he said, this is actual real stuff, and I really, really want to talk about it. And I read the case, and I have no clue what's going on other than there's videos on YouTube. So Dan, please explain why this is important. Why should we care about this show that's from Latin America I had never heard of before? And how best to use YouTube if you want to be on the up and up?
You bet, Anthony. And thanks for
Which,
having
of course,
me on.
all our viewers on YouTube are very interested in.
Yes. So, the case I'm going to be talking about is Athos Overseas Limited Corp. v. YouTube and Google. It's out of the 11th Circuit. Athos Overseas Limited Corp. It's not. Well, I found this opinion to be a little confusing, and I went to the district court opinion, and so I'm going to kind of like fill in some blanks, or at least places where I got confused by some of the stuff that we learned from the district court. But Athos is a Panamanian entity that is owned and operated by a producer who acquired all kinds of rights to largely classic Mexican films, like hundreds of them. And as we'll get into the facts in a little bit, starting in 2013, 2014 or so, they got really upset at seeing his movies on YouTube without his permission. And so this is a drawn out saga. We'll talk about what maybe some questionable strategic decisions that they made along the way, but we're going to ultimately find out that the Court of Appeals and the District Court both were not all that sympathetic to Athos's arguments about whether YouTube had done what it was supposed to do, or if it needed to do more. Right. So, we're going to start with where the law is, and we'll dig in. This is a DMCA case, Digital Millennium Copyright Act. In relevance, the relevant part here, it's trying to strike a balance between the rights of copyright holders and service providers, right? We have the internet is coming along. We don't want to stunt the internet's growth. We want to protect, allow copyright people to protect their rights and their intellectual property. And so they drew some lines, right? Congress drew some lines.
And this was drawn up in the days of Napster, if I remember right.
1998, I think. Right. So yeah, around then. And I may or may not be familiar with Napster. So at any rate, the DMCA includes a safe harbors for service providers, one of which is which YouTube would be one, and the safe harbor says, like, look, you service provider are not liable for damages and very limited injunctive if you don't have actual knowledge of an infringement, if you are not aware of facts and circumstances from which infringement is apparent, and we're going to put an asterisk by this. This is the red flag test, right? That the decision is going to talk about, or upon obtaining such knowledge or awareness, you act to remove. You can't have direct financial benefit, and you have to act expeditiously to take the infringing materials down. Importantly, you have no duty to monitor. You don't have to scour your website. You don't have to scour your YouTube. Doesn't have to look around and see what might be infringing. Because the DMCA, and it makes a lot of sense, puts that obligation and onus on the copyright holder. The copyright holder is going to be in the best position to know whether a copyright has been violated, right? And this has evolved, and it was intended to do so, into kind of the notice and takedown things that we're all vaguely familiar with, right? You get a notice, this is copyright, and then YouTube says, okay, I'm going to take it down, and I'm going to put a mark against that user. They accumulate enough marks, we're going to disable the account, right? And you see this regime, or this type of regime, all over the place, whether it's in this case, or it was also at issue in the Sony versus Cox case that's pending before the Supreme Court, and unlike in that instance, YouTube responded, right, and they took down the materials. So let's walk through this a little bit more. For service provider to be covered, to be fine of it has to adopt and reasonably implement a policy, has to expeditiously remove, no financial benefit, and now our story begins. 2013, 2014, the Athos owns hundreds of classic films, and it began to send takedown notices to YouTube. And the record, I found the decisions to be a little bit confusing on the volume of takedown notices that it sent, but it was, I believe the number is 7,000 in total.
Wow.
I think it was 3,000 plus for the relevant period that's in here, and so it's all these clips, things for infringes, and YouTube took them all down. Like there is no argument that YouTube did not to say, oh, we got a notice, we took down the infringing material. Right.
And how long was the gap between the notice and the takedown? That's what I couldn't tell from the opinion.
I don't think I don't know that it was discussed off the top of my head, but it's pretty quick, right? Like YouTube moved pretty fast on this, and there was no argument made that YouTube didn't move quick enough once it received a takedown notice.
It's not like weeks and weeks go by and it's still up there or something.
Right. Okay. Right. So now, so we're a little bit familiar with Athos, giant library of largely classic Mexican films. Right, that's and they're upset that their films or bits and pieces of it are showing up on YouTube in ways that aren't consistent with the rights that it has. YouTube is YouTube, right? As of in the district court opinion, it noted that it's about relevant time, as of February of 2020, YouTube was adding 500 new hours of programming every minute. Right, so it's an enormous. We all know it's enormous, but that kind of jumped out. Like got a lot going on, and so what YouTube has done is they have created content. They've created tools to allow content owners to more effectively find or locate the infringing materials. They've got great names like Copyright ID, Copyright. So the effect of these tools is to make it easier for content owners to submit takedown requests by identifying and suggesting possibly infringing works, right? So in some of the more confusing parts of the decision, the court attempts to describe how the technology works. It uses things like hash and digital thumbprint and blah, blah. The district court did, in my opinion, and hopefully they got it right, a much better job of describing how this stuff worked by saying the copyright match tool is automated software that, through the use of encoding and fingerprinting technology, detects videos that match a user's copyright material and presents those matches to the user. And the Content ID is automated software available for users with more complex management needs, and you have to upload the verifying materials and so on and so forth. But in both of these, the YouTube's going to suggest, hey, it looks like we might have some copyright infringement going on, and it makes it easier for the copyright owner to kind of submit the takedown notices, indicate that. However, and this is where the worm turned. When you sign up for those, you agree not to sue YouTube. it includes a release, right? And Athos made the business decision at the time that it would rather do the individual 7,000, 3,300, whatever it would say, thousands of takedown notices to YouTube and preserve the right to sue than to subscribe to tools to make it easier to police its copyrights, but and give up the right to sue. Right? That was the business decision that was made, and they preserved that right to sue, and they did sue, and it did not go well for them. Right? The decision starts to walk through the various the tools that YouTube provides. It kind of tries to explain how it all works, but what it makes, one of the things that the court says, and it's true, is that all of these tools are operated by the copyright holder, right? Because the copyright holder is one in the best place to know what copyright materials are and how to police them, but also the copyright owner is the only one who knows what's going on legally. None of these tools are capable of doing a legal analysis to say, is this a fair use?
Right.
Did the copyright owner sublicense the content to somebody? Is it an affiliate? Is this permitted? There's no way to automate that, right? Like that's got to be done by the copyright holder. Only the copyright holder knows that information, and this is going to be very relevant to the courts, to some of the court's reasoning as it gets along, and whether YouTube had enough notice or had some burden to solve, that a burden to carry that they failed to carry. Right? So the decision talks about whether YouTube has either actual or red flag knowledge as a result of this content production. So it's proposing, Athos is saying, like, look, YouTube has the capability, and it does, to suggest infringing materials. Why isn't that at least constructive notice? Like, why isn't that like enough? Why isn't enough going on there to suggest that infringement is happening and to give YouTube an obligation to do something with that information,
even without the takedown notices? They're saying
that's
you
right. So we're talking a little bit about that red flag standard, right? Like it's and the red flag standard is the decision quotes and goes into a relatively well-known treatise on copyright by Nimmer, and it says suggests that the red flag test goes to generalities. Like, the infringing activity is apparent, not the infringing activity alleged in the complaint. So, like, for example, if YouTube's CEO picks up the newspaper, and in the newspaper there is an article that says, man, there's a lot of pirated content on YouTube, has the YouTube CEO received enough notice of what's going on that they have an obligation to do something about it? And the court's really, really skeptical of applying this standard in this type of situation. It says, look, there are probably some services out there where, like Napster, where you have like directory based, right? Where you say like you're where that type of constructive knowledge, that type of red flag is sufficient. But where you have, the no way to know what the analysis is, to know where you're not the copper, you don't have the, like, you're running really, really close to making to running headlong into the obligation, or the what the DMCA says service providers are not obliged to do, which is monitor their libraries.
Yeah.
Right? And given that the copyright holder is in such a better position, the only position, to know whether something is violating its rights or not, given both they own the material and they have the legal relationships, right? That there is no, we're not going to impose that obligation on YouTube. And sorry, Athos. Now, the Second and Ninth Circuit had already looked at this. They had decided it in a much similar way. This decision goes a little bit further, I believe, than those on the red flag standard. And ultimately, this is a pretty big, a pretty bad loss. Pretty bad loss for Athos and its library of classic Mexican films.
Hang. So they could have put themselves in the YouTube system and got all the benefits of that, but they did. Now I want to ask a little bit about like what that could have given them. But first, I want to see what Sophia thinks about all this, who I'm guessing does not remember Napster.
I think I remember my dad using it when I was a kid, actually.
Oh, that's harsh.
So I do remember it a little bit. But
You guys were a Napster household. That's great.
I think so. Yeah. Yeah, but I have very little experience with copyright laws, so I sort of more so just had a question. I don't like the outcome here, especially in terms of the red flag stuff, seemed pretty straightforward to me. Like, I didn't really see how the court could possibly reach a different conclusion. So I was just wondering, like, am I missing something like that should be more controversial? Because it seemed to me like the common sense.
I think that's right. The both of the courts that had looked at both of the courts of appeals that had looked at this issue before had come out the same way. I think this decision maybe goes a little bit further than what had been done, and it's definitely crystal clear on YouTube's doesn't have an obligation. This red flag, this facts and circumstances aren't going to rise up to the level to ask a service provider to do the extra work or take down the materials. I thought this was interesting because I feel like there's a little bit of a movement out there and making it harder for the copyright holders to find their remedies, right? And it makes it a little bit tougher. One of the things that maybe anticipating Anthony's question a little bit, it is an uphill climb for a copyright owner to sue YouTube.
Sure.
Right? It
You're
really
suing
is.
Google.
Or suing Google. In addition to all of the practical considerations, like, this is YouTube's business. They have produced the tools that are out there. They've won these cases before, and they have the suite. These things. They say, hey, content providers, we can't inventory. We got 500 hours of new content every minute 5 years ago, right? Like we're automating this. We've invested hundreds of millions of dollars into these tools. Take advantage of these tools. You can't sue us if you do. And so this business decision that Athos made, I found to be, there's like an intellectually appealing part to it, standing your ground. I'm not going to, click into this form contract, et cetera, et cetera. But if you're really interested in getting the copyright the materials off of YouTube that violate your copyright, like, these tools provide a way to do that. Right, and they're designed for this purpose, and so I kind of think, like, before they filed that lawsuit, it might have made sense to start, like, what's our real goal here, right? Because the path to getting there is a path to getting the videos off, many of them, however many it is, and it avoids this litigation that has not been successful the other times that people have tried it.
Mm-hmm. So, quick correction. You're right. Napsters began in mid 1999, so the DMCA was just before it. But I remember, there was basically proto Napsters already starting at that time, and MP3s were flying around the internet, and that was driving it. And Napster, of course, tried and went and flamed for a while, and then burned out because of the DMCA.
Well, and I don't know that anything was flying around that back then, Anthony. I was putt-putting at 56.6K modem, right? Like it was slower traffic. Slower traffic.
Wait like half an hour for the song to download, and
yes.
Yeah.
Yes.
Of course, I didn't actually do that myself, but so the question I have is, so say you opt into this YouTube system. I'm guessing, like, the problem with a contract like that right, is then what if YouTube just falls down on the job and isn't doing that? Is there? They probably don't talk about this, Dan, in the there, but I would think there's some kind of a best efforts part of the contract or terms of the service where if it really wasn't happening, maybe you could opt out and then sue. Because that is a lot of trust to place in Google to, like, protect your stuff.
So great question. Not only does the opinion not go into it, and I don't personally know what's in
Sure.
YouTube's terms and conditions then or now, right? But the record, I am taking at face value how the district court described Athos's motivations for not signing not entering into those agreements, which is when they wanted to preserve the right to sue. I don't think it was super clear cut. I think I think there were, and so it's not totally known why Athos had the reaction it did to terms and conditions. I suspect the hunch that Athos is looking at it and says there are literally thousands of copies of my movies. Of either snips or clips floating around YouTube. They can produce a list. If I sign up this, they can produce a list. I just go copyright violation, copyright violation, copyright violation. Gosh, it seems like they know what's going on, and there's a part of it that like, yeah, that makes sense. But YouTube, it's automated. There's nobody there that's looking at with them, and even if somebody was looking at each of those, they'd have no idea what Athos had said had been a permitted use, or I'm gonna analyze 500 hours of new content every minute to determine which portion of those is fair use. Right? Like those are not automated. Those are not automated processes.
Right. And it is. I have to say, the little I know about it, it is amazing how these YouTube's programs the algorithm will go click and find something on there and send the warning out. So. Sometimes they're not accurate, I will say, but they're fast. So,
yes. No, as I say, there are all kinds of feels out there on the notice and takedown system when it's used correctly, when it's abused a bit, those types of things. But whether people send them or robots send them, right? And so there are. It is the system that has evolved as kind of the DMCA contemplated.
Right. Well, we all like enjoying our YouTube, of course. You can, of course, watch it on your phone. And sometimes people, they will watch YouTube on their phone at the beach. But if they're at the beach, you maybe want to be a little comfortable. Get a lawn chair, get an umbrella, sit there with your drink with an umbrella while watching YouTube on your phone. But unfortunately, in some places, that practice has been given to monopolistic forces that depress one's ability to earn a living. And so there was an attack on one of those monopolies in little old city of North Myrtle Beach. But the city, unfortunately, had some protections. So, Sophia, tell us a little bit about this, but I'm also curious, have you been to the city of North Myrtle Beach or Myrtle Beach itself, and what's it like?
I don't think I have. Have you?
No, I've been to the beach in South Carolina, but or wait, is it North Carolina? I think it's South Carolina, isn't it? I mean, there is some Southerners probably, turning the channel right now. I just know it's a place to go. That the beach is nice. You go spring break, that kind of thing. Dan, you probably have some knowledge about that.
I'm trying to decide whether the Southerners are leaving now or when you mispronounced the name of the college.
Yeah, that might have happened early. Anyway, I've done my research. Yeah, Myrtle Beach. It's a little. I've been to Charleston. It's a little north of Charleston in South Carolina.
Yeah, my family typically goes to the beach in North Carolina, so I haven't been to the South Carolina beaches too much.
Understood. It's very close to the South Carolina or the South and North Carolina border. I will add. So anyway, that's where we are. What's going on the beach?
Yes. So this case is Cherry Grove Beach Gear versus City of North Myrtle Beach, and it's out of the Fourth Circuit. And this case is about when cities are immune from federal antitrust law. So this case comes out of North Myrtle Beach, which attracts around 2 million visitors per year. Wow. So a very popular destination. And so understandably, a large percentage of these vacationers want to rent beach equipment like chairs and umbrellas. And so that's where the plaintiffs in this case come in. So plaintiffs are the owners and operators of a company called Cherry Grove Beach Gear. They rent beach equipment like umbrellas and chairs to vacationers. And when you rent from Cherry Grove Beach Gear, you can choose to just come pick up your equipment, or you can pay Cherry Grove Beach Gear to set up your rental equipment on the beach for you. That is up until 2021, when the city of North Myrtle Beach informed Cherry Grove Beach Gear that their beach setup services were in violation of city code. So because Cherry Grove essentially disagreed with the city's interpretation of its code, they continued to provide their setup services. In response to this, the city passed a new law in 2022 that unequivocally barred Cherry Grove from providing their setup services. So the 2022 ordinance stated that only city officials are allowed to set up rented beach equipment on the beach in a commercial context. So under this ordinance, Cherry Grove can continue to rent out its beach equipment, and it can even drop off that equipment at your beach house for you, for example.
Wow.
But it cannot bring your umbrella and chairs to the beach and set them up. So if you want that done, you have to rent from the city. So in spite of this ordinance, Cherry Grove continued to provide their setup services, but after receiving multiple citations from the city, they ended up bringing a federal antitrust lawsuit against the city of North Myrtle Beach in the United States District Court for the District of South Carolina. So Cherry Grove alleged that the city of North Myrtle Beach violated federal antitrust law because it sought to impose an unlawful monopoly on the rental of beach chairs and beach equipment on the entirety of the beaches.
And from what, I don't know if it's in the opinion or not, Sophia, but it sounds like these beaches are all publicly owned. They're not like privately owned by the property owner at the edge of the beach.
That's my understanding, yeah.
Yeah. Okay.
Right. So the district court disagreed with the plaintiffs, and it ended up granting summary judgment to the city because of an immunity doctrine known as state action immunity. So this state action immunity doctrine provides that federal antitrust laws do not apply to anti-competitive restraints that are imposed by states, as long as those restraints are imposed as an act of government. So in other words, the immunity attaches only when the city is acting pursuant to a policy to displace competition through regulation or monopoly.
Right, because
So-
in some senses, regulation is always monopolistic, and so
Right.
it's just exempt from antitrust.
Yeah. So the plaintiffs disagreed with the district court, and they appealed to the United States Court of Appeals for the Fourth Circuit. So the plaintiffs raised two arguments on appeal. First, they argued that state action immunity cannot attach because the state statutes at issue are not sufficiently clear explanations of state policy. And then secondly, and I thought this one was interesting, they asked the Fourth Circuit to adopt something known as the market participation exception to state action immunity. So under that exception, the city would not receive immunity because it was participating in the market as a competitor instead of acting in a regulatory capacity. So the Fourth Circuit ended up disagreeing with the plaintiffs on both counts and finding for the city. So first, it finds that the state statutes are sufficiently clear explanations of the state's intent to impose a monopoly on beach equipment setup. And it honed in on a couple of state statutes in its analysis. It looked at the fact that South Carolina's statutes authorize municipalities to grant franchises and make charges for the use of public beaches. And they also authorize municipalities to provide lifeguard and beach safety services. And one of the things that they can do is grant the exclusive right to a beach safety company to rent only the beach equipment and sell only the items to the public on the beach that are allowed by the municipality.
So I mean that's pretty specific. They explicitly have the right to let someone else at least be a monopolist on the beach.
Right.
Yeah.
Right. So, and the plaintiffs tried to kind of differ from that argument by saying, well, okay, we don't dispute that the statutes grant the city the ability to displace competition, but the city would have to farm it out to a private company. They can't just give themselves a monopoly, essentially. But the Fourth Circuit disagreed, and it said basically that because the state has given the city the power to establish this exclusive franchise, the city has the ability to establish a monopoly, and therefore state action immunity attaches. So essentially, because those statutes contemplated anti-competitive conduct, the Fourth Circuit found that the city is going to receive state action immunity. And then the second issue that they looked at was the market participation exception that the plaintiffs were urging the court to adopt. However, basically the Fourth Circuit noted that the Supreme Court has kind of gestured at the possibility of a market participation exception, but it has never held that such an exception actually exists. And the Fourth Circuit didn't give a ton of analysis on this point, but it noted that it had, in a prior case, rejected that exception, and it said that it would decline the plaintiff's invitation to, quote, steer federal antitrust law into uncharted waters.
And onto the beach, perhaps.
Right. Into the ocean.
So, I guess monopolists win. We wait for another day. Dan, IJ, we were very much not into monopolies. And any thoughts?
Do you have any sense of what happened in 2020? Because I in my head, and I don't know if this is right or not. Like we've got this thriving little symbiotic relationship. People go down there, they get the chairs on the beach, they do this, and it feels like it went bad quickly. Do we know kind of? Was there any hint in the record as to why this got so adversarial so quickly?
Yeah, when I was reading the opinion, I had the same question. So I went back and listened to the oral argument, and although they didn't really explain there, but there was a lot of attention paid to the question of like how much money is the city making from this and what are they doing with the money. Apparently the city is using the money to fund the lifeguards. The city's lawyer talked about that extensively. And then the question kind of came up, like, does it even matter what they were using the money for? Could they still do this even if they were using the money for something frivolous? So pretty interesting.
Yeah, it's kind of just, I guess, not a good look if they were making, a lot of money. I would guess a lot of people like beach equipment when they go to the beach, and lifeguards, I mean, they're trained. You got to pay them a bit, but I bet they made a lot more than what the lifeguards cost. That's just a wild guess, but I bet it's more. Then we don't have to raise, people's taxes in the city. We can make all the money off all these 2 million people who visit us every year, kind of like a hotel tax kind of thing.
Right. Yeah, I saw a news article that said that the city was making at least $1.5 million. And then I think there was something in oral argument about how any excess that doesn't go to the lifeguards is used for like maintenance of the beach or general beach like safety. So.
Yeah, I mean, those big beaches, when you have lots and lots of people, it does take a toll on the beach and a few other things. But man, they must make a lot of money off is my guess. So my response, and I bet many listeners and viewers' responses to this is, right, this is an antitrust case, but it sounds a lot like some of the cases we do at IJ about the right to make a living, right? There's this private outfit that is renting equipment to people on the beach. It sounds like a nice little start, what a cool idea. And it's shut down by the city. And not only is it shut down by the city, it's like so the city itself can compete against it on its own. And yet, right, we have a antitrust lawsuit. We don't have a constitutional lawsuit. And people who have been listening to the show for many years will know the reason probably is why they went in this direction is because a constitutional lawsuit is going to be incredibly difficult, because not only is the right to earn a living incredibly hard, and you usually have the rational basis test against you and all of that, but this is that's why I asked that question. This is a public beach. So it's I don't know if the county owns this or the state. I suspect maybe the state owns the beach, but anyway, it doesn't exactly matter if the city itself owns it, but it's public property, so the government kind of gets more leeway there, right? If it's on the beach than if it's someone's own private stadium or backyard or wherever you might be renting stuff. And so it's going to be really hard to bring a right to earn a living claim in that context, whether it's under the state or federal constitution. And so you try antitrust law, and sometimes these antitrust cases do work against cities and state boards. There was a big case a few years ago involving the dental board of North Carolina, where the Supreme Court said there wasn't immunity. But that statute you read, it is kind of on point for what the city was doing. So court was able to let it go.
Yeah, it seemed like, I mean, I could understand why the Fourth Circuit would read those statutes that way. The question that just kept coming to my mind when I was reading it about the market participation exception is it seems like in this case, the state is acting less as a sovereign regulator and more of just an ordinary competitor in the market, except they're shutting out all competition.
Yeah.
So I wonder how, it almost seems like I could see why the plaintiffs were advocating that exception.
Yeah,
but
it's like they're giving a patent to run a monopoly to the city, like in the old days of Lord Cook type monopolist cases. So kind of had that ring to it. I don't know anything about that market participation exception thing. I know we have some friends of the show who do this kind of monopoly work against cities and boards. So maybe it'll percolate, but it doesn't seem to be creating like a circuit split or anything like that.
I don't think so. It seems like a lot of circuits and district courts have declined to adopt it. So,
right. Well, while everyone's sitting at home, some maybe still stuck in the cold, the snow, and perhaps even the ice, forcing them to be at home, we can all think about the summer where we can do things like go to the beach, and maybe there's some more free market oriented beaches out there where you can rent your beach equipment or just bring it yourself, right? Which is, I suspect, what a lot of the people here do. But until that time, thank you both for a little bit of YouTube, a little bit of rentals at the beach, and a little bit of pining for summer. And until then, though, I will say, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.